My name is Helen Blackburn. I'm a solicitor and partner at the International Family Law Practice LLP. I am the author of 3 chapters in the 4th edition of Jordan's International Family Law Practice, and specifically I am the author of a chapter detailing the law and procedure concerning child abduction. Child abduction is a very emotive term. The family courts are not usually called upon to deal with stranger abduction, which is thankfully a relatively unusual event. The vast majority of child abductions that take place involve one parent removing or retaining their child across an international border without the knowledge or consent of the other parent. Child abductions often occur following the breakdown of an adult relationship and when one parent decides to leave with the children and return home. At a time when people married somebody from their own or a neighbouring village, this didn't present a problem. However, as people now marry spouses from all over the world, it causes widespread problems. Child abduction is the area of family law where the international community has shown the greatest cooperation. The primary legal instrument regulating parental child abduction is the 1980 Hague Convention on the International Aspects of Child Abduction. It aims to achieve the return of an abducted child to the state of their habitual residence for the courts in that state to determine their future. It is accepted that it's normally in the child's best interests to have decisions concerning their welfare decided by the courts of their habitual residence. Courts often have to make very tough decisions to achieve this aim. The 1980 Hague Convention is probably the most successful piece of international family law with regard to cooperation and implementation. It is modified as between EU states with the exception of Denmark by Brussels II revised. The Child Abduction and Custody Act 1985 gives effect to the 1980 Hague Convention in England and Wales. Child abduction only occurs when a child is removed or retained in breach of somebody's rights of custody. There are essentially 5 possible defences or exceptions to an automatic return. Namely, that the left-behind parent was not actually exercising custody rights at the time of removal or retention. The left-behind parent had consented to or subsequently acquiesced in the removal or retention. There is a grave risk that the child's return would expose the child to physical or psychological harm or otherwise place them in an intolerable situation. That the child objects to being returned and has attained an age and degree of maturity at which it is appropriate to take into account their views. And finally, that the proceedings were commenced more than a year after the date of abduction and the child is now settled in its new environment. The English court has interpreted these defences and exceptions narrowly. The child abduction chapter deals with the content of the 1980 Hague Convention, its interpretation and interaction with V2R and the 1996 Hague Convention. It also provides information about alternative remedies that exist in the form of the inherent jurisdiction and certain judicial protocols when the 1980 Hague Convention is not available to litigants. The chapter also contains essential information regarding court procedure and practical guidance for practitioners to prevent an abduction occurring and/or assist them in locating missing children.